This is the Legal Eagle with an analysis of Whren versus United States. Here are the facts behind Whren versus the United States. This is another in a series of cases that are known as passenger cases. Whren and Brown were driving in a high drug area. Some plainclothes officers, while patrolling the neighborhood in an unmarked vehicle, noticed Whren and Brown sitting in a truck at an intersection stop sign for an unusually long time. Suddenly, without signaling, Whren turned his truck and sped away. Observing this traffic violation, the officers then stopped the truck. When they then approached the vehicle, the officers saw Whren holding plastic bags of crack. Whren and Brown were arrested on federal drug charges as a result of this stop. Before the trial, both Whren and Brown moved to suppress the evidence, contending that the officers used the traffic violation as a pretext for stopping the truck because they lacked either reasonable suspicion or probable cause to stop them on suspicion of drug dealing. The district court denied their motion to suppress and convicted both Whren and Brown. The Court of Appeals affirmed this judgment, and the Supreme Court granted certiorari. The issue of this case is when an officer has probable cause to believe a traffic violation has occurred, is the Fourth Amendment violated if his primary reason for pulling over and detaining the motorist is not to enforce the traffic laws? Additionally, when there is an illicit motive for an action by the police, plus an objectively reasonable basis to act, does the illicit motive invalidate the reasonable basis to act? The rule for this is if officers have probable cause for any traffic infraction, stopping the car is an objectively reasonable thing to do under the Fourth Amendment. The court held in this case that temporary detention of individuals during the stop of an automobile by the police, even if only for a brief period and for a limited purpose, constitutes a seizure of persons within the meaning of the U.S. Constitution, specifically Amendment 4. An automobile stop is thus subject to the constitutional imperative that it not be unreasonable under the circumstances. As a general matter, the decision to stop an automobile is reasonable where the police have probable cause to believe that a traffic violation has occurred. Therefore, to answer the second issue statement of whether there's an illicit motive for action and an objectively reasonable basis to act on behalf of the police, does the illicit motive invalidate the reasonable basis to act? And it is no. This is rather curious, in my personal opinion. However, if there is an objectively reasonable reason for the police to pull you over, such as a legitimate bona fide traffic violation that gives them a pretext for the search, then I do believe that their search would be covered, although it may be kind of shady. Thank you so much for tuning into my video. If you have any questions or comments, please feel free to leave them underneath, and I'll get back to you as soon as possible. Have a great day.